Good afternoon, everybody. I'm just giving everybody a few seconds to continue to join. Let's see. All right. So let's get it started officially. Good afternoon, everybody. Happy Tuesday. My name is Jorge Acosta Palmer, and I am the director of the statewide training initiative with Florida Legal Services. Thank you for joining us here today for a 1 hour webinar. With great power comes great responsibility. POA Essentials for Legal Aid and Pro Bono Advocates. Before I introduce our speaker, I do want to go through some quick housekeeping announcements. First, this training is being recorded. You're going to receive a copy of this recording and a link to the materials in an email from Zoom, not me. It's going to be a Zoom email within 24 hours. If you don't see that email, I'm going to drop my email here into the chat just in case. Feel free to reach out to me if there's anything that you need. This training is approved for Florida Bar by the Florida Bar for CLE credit. I will announce the CLE code towards the end of the session, and I will also drop it in the chat as well. It will also be included in the Zoom email that you will get within 24 hours. Closed captions are enabled for anybody who needs them. If you're having any issues with accessibility or the captions, you can reach out to me directly, whether it's via email or just drop something in the chat and I'll get with you. This training is being co-hosted by the Public Interest Law Section, otherwise known as PILS. If you're not familiar with PILS, I highly encourage you to take a look at their website. I'm gonna drop the link to their website here so you can learn more about the type of work that we do, the type of work groups that we have. It's highly recommended. And final piece of housekeeping, questions and answers. We do have a Q&A feature where you can drop questions here. You can even mark it as anonymous if you're like me and you don't want people to know who's asking. You can drop them in the chat. Even if possible, I can also have you raise your hand and I can have you come off mute. You can drop your questions into the chat as well. I'll do my best to read out I'll let the speaker know and I'll read out some questions just in case we can answer them live. If any questions come up after the training, if you're watching this as a recording, feel free to email me those questions and I'll do my best to get those answers to you. The email that I will send out includes a link, and I'll drop the same link to the materials folder into the chat as well. We're going to have a copy of the PowerPoint presentation, but we will also have a document where we're going to be compiling other resources as well as the questions and answers that we share here. We will also share some templates that you will see in the presentation. I will be adding those to the folder soon. So without further ado, I'd like to introduce our speaker here today, Aaron Irving. Aaron is a Florida native and was raised in a small town in Central Florida. Aaron joined JALA as the director of Pro Bono in September 2022. Prior to working with JALA, Aaron owned and operated his own law firm in Jacksonville, Florida, Integrity Law, PA. His primary areas of practice at Integrity Law included family law, probate, and estate planning, as well as personal injury. Aaron also served as a court-appointed guardian ad litem in family law matters while in private practice. In addition to his work at JALA, Aaron is an adjunct professor of law at Florida State College at Jacksonville, where he teaches litigation in the paralegal department. Aaron was sworn into the Florida Bar in 2010, and during his tenure in the private realm, was actively involved with JALA as a pro bono volunteer attorney. Aaron is a member of the St. John's Episcopal Cathedral, and his interests outside of work include running, gardening, and reading. So, Aaron, thank you so much for preparing this today and doing this presentation today. So, off to you. Passing it out to you.
Thank you, Jorge, and thank you everyone for attending today. I certainly appreciate being asked to present on powers of attorney. And over the next 50 minutes, I'll try to make this as informative and as exciting, for lack of words, as possible. If you have questions, I'll be monitoring as well the chat feature, and I will try to get to those as we go through today's presentation. And my goal today, of course, is to give a basic background as to powers of attorney, as to some of the terminology and nuances that come with powers of attorney. Speak to you about the types of powers of attorney, some of which you will use more than others, how to counsel clients on these documents, and then maybe touch base a little bit on some of the challenges and legal strategies that come along with contesting these powerful documents. And so to get started, we have to start with understanding the basics of powers of attorney. So power of attorney, the way I usually counsel or even teach gatherings, is that usually you hear of this document in the context of estate planning. Usually that's going to be a durable power of attorney, which is one of the types that we'll cover here shortly. And usually a power of attorney when it comes to estate planning falls under an umbrella term of advanced directives. Advanced directives generally cover a durable power of attorney. It might cover a healthcare surrogate, which is also known as a medical power of attorney. A living will, which is not to be confused with a last will and testament, as well as a designation naming pre-need guardian. Today, of course, my focus is going to be on the power of attorney component, but just be mindful that powers of attorney are generally one part of overall estate planning for benefit of your client, if that is the reason you are drafting a power of attorney. Powers of attorney are governed by statute. That's Florida Statute 709-2101 to 709-2402. I believe the statutes are also going to be included in the materials. It's a lot of fun of dry reading, like any other statute. I'll try to point out some particulars along the way. And these statutes are collectively referred to as the Florida Power of Attorney Act. It came about in 2011. It only applies to those powers of attorney that have been drafted October 1st, 2011 forward, but it does not invalidate any powers of attorney that were drafted prior. Oftentimes you will have clients that have an old power of attorney that predates 2011. And so it's good practice, which we will see, to discuss, updating these documents so that they are the most current version and follow applicable statutes. One thing we'll discuss also, in addition to the execution requirements for these documents, is that a power of attorney is not only in effect upon signing, but unlike a last will and testament, a copy is as good as an original. With a last will and testament, you have to have the original. It's possible to probate a copy of a last will and testament, but there's a lot more steps. And so if you can't find the original of the last will and testament, it's presumed destroyed. A power of attorney, copies are akin to an original. They are generally not recorded. Most all estate planning documents are private, unless it's a last will and testament, and then we deposit it with the court. Powers of attorney, for the most part, will never be recorded down at the courthouse. The only exception to that, which we'll talk about in a minute, will be a specific or limited power of attorney, and that's generally going to be used for real estate. Those POAs are recorded, and that's for purposes of ensuring a clear chain of title when it comes to a real estate transaction. So to start with, what is a POA? There's a court case, Hodges v. Surratt. It's 366 Southern 2nd, 768. It's from the 2nd DCA in 1978. Their formal definition is an instrument authorizing another to act as one's agent or attorney in fact. Now, an agent is an attorney in fact. Those words are used interchangeably, but we're not talking about an attorney at law. We're talking about an attorney in fact. Florida law defines this document as a writing, keyword here is writing, grants authority to an agent to act in place of the principal. And so basically the document creates a relationship, an agency relationship between the two, delegating powers to somebody to act on your behalf. And the way I also explain this to clients, or if I'm teaching law students about these documents, because they might assist me at legal aid with drafting these documents, is to think of it as essentially a document that clones you. It creates a doppelganger, if you will. And that doppelganger, the agent, can carry out those powers listed in the power of attorney. They can act on only on your behalf and in your best interest. So it's not the case necessarily that the agent is substituting his or her own judgment for the person that created the power of attorney. There's a fiduciary requirement that the agent carries out the powers in that power of attorney with the principal in mind, in the principal's best interest. One thing I also tell clients or people, any other people drafting these powers of attorney, is that although it clones you, if you will, it does not take away any powers from you. You still retain the right to do anything under the sun pretty much yourself. You just have somebody else that can act, the agent that can act in your best interest and on your behalf, just in case. And so there are key players in a POA. We have the principal. Again, we have the agent, also known as an attorney in fact, and then of course the third party. So the principal, of course, is the person that's granting authority to another to act on his or her behalf. And that is defined in 709-2102-11 with who a principal is. The principal simply just has to have capacity to understand the document that they are signing and understand the powers that they are giving to whomever they list in the power of attorney. The agent is the person who's receiving that authority on behalf of the principal. And you can have more than one agent. You can have co-agents. I generally caution people from having co-agents in a document because the wording has to be pretty clear. Do these agents, do they have to make decisions in concert, meaning they have to make a joint decision? And I caution people on that, because what if you have two co-agents and there's a stalemate and they want to make a decision on behalf of the principal and the principal can't step in? Then we have an issue. If you don't have specific language in your power of attorney as to the co-agents and how they have to make joint decisions together, then technically speaking, they are on equal footing. And one may make a decision independent of the other, even though they are co-agents. So that likewise can create some issues when it comes to decision making. I generally tell people that in these documents, if necessary, you should have a primary agent and you should have what we call a successor agent or alternate agent or alternate attorney in fact. It's all the same. And it means exactly what you think it means. You have your primary agent who can carry out decisions on behalf of the principal. But in the event that agent A is unavailable, then you have agent B who is able to step in agent A's place and carry out those decisions. The powers that the agent A is given in a power of attorney is the same powers that agent B will have. They transfer. So even though it's a successor agent, those powers still transfer down to the successor, and you can even have multiple successor agents. I've had plenty of clients that have multiple children, and they want to ensure that all of them are listed in a particular document, but in a particular order. Unlike if we go back to Contract 101, which I took many years ago and gives me PTSD, there's the traditional agency principal relationship. It's a little bit different with Florida POAs in that we're not inferring conduct necessarily for the agent's powers, nor are there any powers that are implied. Everything, if it's done correctly, is in writing. And that evidences, of course, clear intent on part of the principal as to what powers he or she wants to delineate to that agent. And we'll see through drafting various POAs what powers you can delineate and what powers you cannot when it comes to a POA. You don't have to have the agent's permission to list them as an agent in your POA. In fact, there are very few requirements as to who can be an agent. In fact, in Florida, you just have to be 18 years of age or older. You don't have to be a Florida resident. You don't have to have any relationship to the principal. You don't have to have a blood relationship or even a friend relationship. The agent does not even have to live in the state of Florida in order to be an agent. Of course, I would hope that clients would have forewarned their agent that they will be listing them in the documents, just so that they know and are comfortable, if necessary, carrying out those decisions on behalf of the principal. The agent also has a right to be reasonably compensated. And in addition to an agent merely being required to be somebody who's 18 years of age or older, you can also designate certain financial institutions as an agent in these documents, as long as those financial institutions have trust powers and they have a place of business in the state of Florida. So it doesn't necessarily have to be an individual themselves. Of course, the third party is the individual or institution who's relying on this document, this power of attorney. More often than not, it's going to be a financial institution as the third party that's relying on this document. It could also be a medical facility. Maybe somebody has to gather documents on behalf of the principal. I've seen them done for schools, as well as a real estate buyer relying on a power of attorney so that they can buy the principal's property because the principal is unavailable or can't be there in some sort of capacity. So moving on to the types of powers of attorney. There's a general, a durable, a specific or limited or special, it's all the same. We have springing or contingent, which are no longer valid, except a small exception for certain military power of attorneys. And then, of course, a medical power of attorney, or sometimes you'll hear it referred to as possibly a healthcare surrogate. Most of what we're going to talk about today will be, and what most of the time you will use in private practice will probably be a durable or a specific power of attorney. So the general power of attorney doesn't differ too much from the durable, but the general usually gives the agent very broad powers, that the agent can carry out almost anything under the sun on behalf of the principal, no different than the principal can do for him or herself, with a few exceptions. There's usually catch-all language in this document. For example, the catch-all language that I've seen and maybe used will be something to the effect of, I authorize my agent to do anything on my behalf, which is now authorized or maybe authorized later under law. And then I'll go into a litany of particular types of powers. And that's merely to evidence the intent of what everything on my behalf means. So usually my power of attorney for this type is about 6 pages on legal paper. So you're probably looking at about 10 pages on regular 8x12 paper. The general power of attorney terminates under a few situations. You have revocation by the principal, which is either in writing or it's physically destroyed along with all the copies. Incapacity of the principal or death of the principal. The difference between the durable and the general is that it survives incapacity, which is why this is what you'll primarily use when it comes to estate planning. It's probably the most common type. It's essentially a general power of attorney, but with specific language that Florida statutes require. In fact, it's 709-2104 that essentially reads, this durable power of attorney is not terminated by the subsequent incapacity of the principal. Doesn't have to be exact. You can use similar language to that. But if your principal is incapacitated, vegetative state, as long as they are alive somehow, this power of attorney is still valid. It still contains that catch-all language, just like a general POA, and might still list all these specific powers that the agent may carry out. But again, it's important to have this because it survives that incapacity. And at the height of COVID, we would often receive phone calls in my law office from a loved one who would say that, his or her loved one is incapacitated, they're incubated, if you will. And we need access to their bank account. We need to talk to the mortgage company, but they won't talk to us. We can't go to the bank, that sort of thing. What can we do? And I would first ask, did your loved one have a power of attorney that would allow you, a durable power of attorney, that would allow you to act on your loved one's behalf? And in that situation, usually it was no, which is unfortunate because if there were a durable power of attorney, then the loved ones could carry out decisions for the principal that was incubated. But because the principal never had one, or maybe the principal only had a general power of attorney, which does not survive incapacity, then I would have to counsel them on obtaining a formal guardianship in order to make these decisions on behalf of the principal. You can also have a durable power of attorney for minor children. Oftentimes, you will have grandchildren that are left in the care of their grandparents, and a power of attorney from one or both parents to the grandparent might give them authority to, make medical decisions on the grandkids' behalf, obtain school records, enroll them in school, and the like. Otherwise, there is a court process and family law to obtain those custodial rights, but a power of attorney for minor children might be sufficient for that particular situation. Then we have these special or limited or specific powers of attorney. These documents don't contain broad powers. Usually it's going to be used for a one-time situation. Generally, it's going to be used in real estate transactions where the seller is unable to be present at a closing, and the closing is not going to be handled in a remote fashion. So somebody, and I used to be designated when we had a title company as part of my firm, would be designated as the special power of attorney simply to carry out the signing and closing documents on behalf of the seller. For real estate powers of attorney, so only in those involving the sale of land, the document doesn't necessarily look different from a deed in a way. It will have it's required to have the full legal description. You need to have enough identifying information for the property. So I always put the legal description and then commonly known as, and then the standard address, property appraiser's ID, and even language such as why the special power of attorney is needed and what that power is for, and that would be for a closing for this particular document. And real estate powers of attorney are generally going to be recorded as opposed to other powers of attorney, which are private. And that's simply to effectuate a clear chain of title when it comes to the real estate transaction. You likewise might have a special or limited power of attorney because you're traveling overseas and somebody needs to carry out some business for you while you are overseas. Maybe it's to obtain documents from an institution, or maybe it's even to compromise and settle a claim or sign a contract on your behalf, and you don't necessarily want to do an all-encompassing durable or general power of attorney. You'd rather limit it to one specific event. The springing or contingent POAs, since 2011, when the Florida Power of Attorney Act went into effect, those springing or contingent POAs are no longer valid. We don't use them. Essentially, they would, the agent's ability to act would spring into being at some future event. That could be incapacity or some other time in that power of attorney. From my research on that, I believe the legislature was concerned about that springing event being abused because it didn't define necessarily what incapacity was or how necessarily approved it. And since the Power of Attorney Act came out in 2011, we see that powers of attorney are in effect upon signing. And so there's an immediate effect. There's no springing to take place in the future. And with the creation of our durable powers of attorney, we see that those survive incapacity. So there's no real need for a springing or contingent type power of attorney. The only exception that I could find to that, and there's a Florida Attorney General opinion, would be for those for the military. There are certain, I believe they refer to them as contingent POAs, that the power is contingent on the serviceman or woman's deployment. And so those, of course, are recognized. But generally speaking, we do not have springing or contingent POAs in the state of Florida any longer. Lastly, we have medical power of attorney. Usually these are separate from a durable. I refer to them as a healthcare surrogate, where an agent or a surrogate is able to carry out medical decisions on your behalf in the event that you are unable to. You still retain the right to make your own decisions while you can. And if they are contrary to what your surrogate decides, your own decisions, as long as you are of the right frame of mind, will always supersede theirs. Generally, this is going to be done in a separate document as part as estate planning, as part of advanced directives. I even put medical language in my durable power of attorney. You'll see that there's a lot of crossover sometimes between a durable power of attorney and some powers listed in a medical power of attorney. And that's simply because you might use them at different times and in situations. And, you know, the lawyer's job is to dot all the I's, cross all the T's. And so I will put in my durable power of attorney that unless a separate medical power of attorney has been drafted, that the durable power of attorney provides the agent with certain decision-making on behalf of the principal. And I'll always put in the durable, as well as the medical, but also in the durable, a HIPAA release. Of course, HIPAA, you can't obtain somebody else's medical records without their permission. And so I will put that in the power of attorney. So we've hit on a few of these, the common uses for POAs, and I'll hit on these again in a little bit moving forward. But you're going to see them used a lot in housing. And this is separate from real estate, but housing, it could involve using a durable power of attorney or a general power of attorney or even limited, for signing a lease on somebody else's behalf. Maybe for those that own rental properties, you might have a limited or general power of attorney for your management company to carry out the management and maintenance for your rental property, including signing leases. You'll have them in consumer, of course, especially when it comes to financial matters, somebody doing banking on your behalf, withdrawing funds, paying bills, speaking to Comcast on the phone, if you will. Of course, we talked about real estate and how real estate transactions have some nuances when it comes to drafting these to give the agent proper authority to sign. And I just hit on healthcare uses for a power of attorney. So when it comes to drafting these documents, there are several requirements that are necessary, not only for counseling the clients, but that are necessary for ensuring that it's a valid power of attorney. It has to be in writing. There are execution requirements we'll get to in a minute, but of course the document needs to be reduced to, a written power of attorney. The length is contingent on what powers are going to be in it, but it has to be in writing. You have to identify the players. Who is the principal, number one? Are there agents, one agent, two agents, three or four? Is the agent an organization? Do you have information for these agents? The power of attorney only requires the name of the agent be listed in the document. I list identifying information such as the address of the agent and successor agent in these documents. That's simply for contact purposes, if you will. But people move, and one question I often get is, if my agent moves and their old address is in the document, does that invalidate the power of attorney? And the answer is no. Now, it might be a good time to get a new one, but it does not invalidate it. And the client can't simply cross out and write in the new address and then initial it. You would want to get a new power of attorney at that time. In addition to the identifying information for the agents, again, they don't have to be relatives. They don't have to be friends at all, actually. But most people will list a relative, whether it be their spouse or other types of relatives, including children, in these documents. And one question I often get asked would be, I have multiple children. Who should I choose? And to make them laugh, I always say, pick your favorite. But if that's not the case, then I say, well, in a durable power of attorney or general power of attorney, for example, which has broad powers, and you'll primarily use that for financial institutions, which of your children is probably best when it comes to finances or would be mature enough to carry out decisions on your behalf and in your best interest? And usually that guidance will help the client choose who they want their primary agent to be, as well as who the successor agents will be. And the successor language for a power of attorney really is pretty short. So usually what I put in my document is that if the primary agent resigns, dies, is incapacitated, is no longer qualified to serve, or declines to serve, because the agent does not have to carry out any powers, even though you list them in the document, then I list blank as successor agent with all the powers, so on and so forth, that the primary had. No matter the type of power of attorney, the successor agent is not liable for any acts of the first agent, nor do they have to review necessarily any acts done by the first agent. They're not personally liable for the acts or omissions of that original agent. Of course, it sounds self-explanatory, but after consulting with your client, you'll want to know what type of POA to draft. More often than not, you will know this at the onset of a consultation, but is it going to be a general? Is it going to be a durable and have those powers that survive the principal's incapacity? Or is it going to be limited to a specific act? There are also exceptions to these broad powers. So generally, you have that catch-all language that whatever I can do, my agent can do, and here's a whole list of things. But even though the document creates a doppelganger, there are certain exceptions to an agent's powers that they are not allowed to do in a POA. And I actually list these in my POA. It will say, notwithstanding the above powers, here's all the things they can't do. This is from 709-2103 Florida statutes, or excuse me, 2201 subsection 3. An agent may not perform duties under a contract that require the personal services of the principal. The agent may not make an affidavit as to the personal knowledge of the principal. Vote. An agent can't vote for the principal. They may not execute or revoke any will or codicil on behalf of the principal, nor may the agent exercise any powers that the principal has because the principal was granted that as a trustee, if you will, or some sort of other fiduciary. You also need to know if your power of attorney will contain superpowers. There are certain powers that the Florida legislature and their grand thinking, don't ask me why, but they decided that they are so powerful that if we are going to give them to an agent, the principal not only needs to know what they're giving, which hopefully they should know because you've explained a power of attorney to them, but the principal has to separately initial or sign adjacent to each of these powers, and there's 7 of them, evidencing their intent to give that authority to an agent if necessary. Usually I have my clients initial instead of sign 7 additional more times. I do try to explain them to the best of my ability to them. You'll usually see these superpowers only listed in a durable or a general, but again, you're probably going to be drafting durable powers of attorney more often than not. And they are covered by 709-2202 Florida statute. And I actually copy and paste from the statute this language in my power of attorney with an initial spot adjacent to it. So the first power would, under the superpowers, would be to give the agent authority to create a inter vivos trust, a living trust on behalf of the principal. With respect to that trust, power number 2, does the agent now have authority to revoke, modify, or terminate that trust, provided the trust also has language that somebody can do that on behalf of the grantor and settler of the trust. Power number 3 is make a gift. Usually gift is going to be in the context of the federal gift tax exclusion. Essentially, right now it's $18,000. You are able to gift $18,000 to as many individual beneficiaries as you like without having to pay taxes on that gift. You can do that annually. Next power would be to create or change rights of survivorship. An example of that would probably be for joint bank accounts or jointly owned property. It's a superpower, of course, because that's something very important, but I imagine that would come up in the context of estate planning in an effort to eventually avoid a probate, that maybe the principal had a singular bank account, and you now want to make that into a joint bank account so that when the principal dies, it's already jointly owned with somebody else, and you can avoid probate. Another superpower would be to change a beneficiary designation, or payable upon death, if you will, on an account, simply because this is a way to avoid, again, probate. Then there are the other two examples would be to disclaim property on behalf of the principal, or waive the principal's rights to an annuity or a survivor benefit. I think that might only come up in the context of if the principal is in a long-term care facility that's maybe paid by Medicaid. And if they were to come into some sort of funds from an annuity, it might disqualify him or her for having Medicaid maybe pay for the long-term care because they would have too much income. So those are those special superpowers that you need to be cognizant of, explain to your clients thoroughly as well. And then, of course, will you have catch-all language in addition to listing specific powers, or are you just going to have a standard limited power of attorney with only certain powers for the document? Did the client have an old POA? Where is that old POA and what do we do with it? We'll talk about that in a second. And then, of course, we have the signing requirements. Let's see, a question was posted. POAs that are signed by a person who has developed Alzheimer's. Okay. Good question. So moving on to signing requirements. The principal must sign the document. Okay. Now, I've had plenty of clients in my office that might have, dementia, early onset type Alzheimer's. And all the law requires, and this is the same when it comes to estate planning for doing last will and testament, is do they understand the document in that brief moment in time that they are signing it? And usually if you're doing this long enough, you can kind of gauge if the client understands the documents. You can kind of gauge if someone's pressuring them to sign the documents. I think I've only ever had one instance where I had to tell the client, let's come back on a better day because I want to ensure. And usually I ask certain interview questions once they're ready to sign the document that give me kind of a good understanding whether or not they are cognitive to sign it. And it might be basic questions such as, what's your birthday? Do you remember who the president is? Do you know why we are here? And that sort of thing. But the principal has to sign the document and it must be notarized, but only the principal's signature has to be notarized. There also need to be two witnesses. The notary can likewise serve as a witness, but there should be two witnesses. I'm a big fan of ensuring that they are disinterested witnesses. Even though the notary is only required to notarize the principal's signature, in my practice, I had the notary likewise notarize the witnesses' signatures. So in that case, the notary cannot serve as the witness because the notary can't notarize themselves. But I usually was the notary in my own office, and then I would have my staff serve as the two witnesses. And then, of course, I would have the principal sign as well. If the notary is unable to sign because maybe they have a medical condition that's affecting their ability, but as long as they're still cognizant, then the notary can assist the principal or even sign on the principal's behalf. I've not done that. If anything, I have helped guide the principal to the best of his or her ability by helping with the pen while they moved it and made their own signature. I'm going to skip over this since we've kind of covered it ad nauseum, and I want to ensure that we don't run out of time. There are certain ways that you revoke a power of attorney. So the first one is if the principal dies. You know, these documents are only good while the principal is alive. Same with all the advance directives. Once the principal dies, they all cease to exist, and then you move into what the last will and testament says, and if a probate is necessary. Second is if the principal is incapacitated and you only did a general or a limited power of attorney, and you did not create a durable power of attorney, which has that spiffy language from statute that it survives incapacity. The principal can also revoke the power of attorney. Now, there's multiple ways to do a revocation. There could be a revocation in writing, and that you might want to record so it's a public record. Or I ask my clients, do you have your old POA? Are there any other copies, or is this the only one? And if this is the only one, then I'll shred it for you and now it's destroyed. Or we can even put in your new POA a reference to the old one that you are specifically revoking that. If you don't put that specific language in the new POA, then the old one's technically still good unless somehow you've destroyed every single copy or you've done a separate revocation in writing. A power of attorney can terminate because the purpose is accomplished. It's a limited POA, and everybody finished what they needed to do with the selling of the home. Maybe it has a termination date that this POA is only valid while I'm in Europe for the next 6 months. Or maybe it terminates because the agent's ability to act ends because the agent passed away, but there's no backup agent, or the agent is removed by a court of law or resigns, and that sort of thing. And again, that there's no backup agent. One thing to bring up is if, let's say the parties are married, and often the case in estate planning, the principal lists their spouse and vice versa. They do mirror documents, but they list their spouse as their agent to carry out powers. Well, if a party files for divorce, it doesn't mean the divorce has to come to a conclusion with a final judgment, but just the filing of the divorce negates the agent's authority in that POA. I sometimes recommend just somebody doing a revocation in writing. It's a one-page document. It doesn't have to be recorded, but some people record those just so that there's always a public record for that particular document. We've kind of gone over advising clients on a POA. You know, step number one, explain the purpose of the POA. Explain what it is and what it's not. Explain how it is not going to take any powers away from the individual, that they're still able to act on their own behalf. But if you're doing a durable, why it's important. Explain a real life situation such as the COVID scenario I gave you, how it can save your loved ones from a lot of time, trouble, and financial heartache because they don't have to do a formal guardianship, if you will. Make sure that all the parties have been identified. Address those client concerns. You know, a durable or even a general, they are powerful documents. And I will receive questions a lot of times. Someone will say, well, Aaron, what is stopping somebody from going to the bank with this document and pulling all my money out? And I will say, well, at the onset, nothing. But why did you give this person that power? I know that sometimes families kind of fall apart, or you know, whoever you list as your agent, you might not have a friendship with anymore. Then I will say that, you know, there are certain protections under law that might not be immediate, but there are certain protections that prevent somebody from abusing their fiduciary capacity as your agent. Not only can they be, you know, civilly liable, but of course they can be criminally held accountable for elder abuse and the like. Excuse me. I always provide a draft to my client prior to signing. Usually I would have emailed it to the client or mailed if necessary, so that they can read through this on their own before they come back to my office to sign the document. And I still go through all of the powers in that document, especially those superpowers and why they have to be initialed. I would say that 99.9% of the time, my clients would initial next to each of those superpowers because while they might not come up, it's good to give that authority to your agent. If you already otherwise trust them with everything under the sun, you might want to ensure that they have every power imaginable. And then, of course, I do discuss the signing requirements.
And we do have another question in the Q&A.
Okay.
I'm going to read it out loud for the benefit of the audience. If a durable power of attorney is executed and later the principal executes a specific POA for real estate, does that POA terminate the first original durable power of attorney?
No, good question. It does not. I've had them done. I've done both of them. You know, the durable, even though it has a standard catch-all language, generally will not have language specific enough for a real estate transaction. And also, even if the durable did, you don't want to record that document. It's lengthy. It's got a whole bunch of your business in it. So you would want to have a separate limited solely for that real estate transaction, but it will not negate the other document unless you specifically put language in there that it negated the other document. In the last couple of minutes, I just wanted to share some grounds for contesting POAs. You know, third parties that are relying on this document, they have to accept or reject it. If they reject it, they have to do so in writing. Now, more often than not, if you take a document like this to the bank, they are not immediately going to accept or reject it. Probably bank staff, they don't know what to do with it. So they are probably going to say, we have to send this up the totem pole. And they will send it to their counsel's office just to make sure that they do their due diligence and that it's a legitimate document. But very rarely will financial institutions, I think, immediately rely on it. The financial institution may require the agent themselves to do a separate affidavit. And that separate affidavit that the agent signs says that I, as the agent, have no reason to believe, or I've not seen anything that this POA has been rejected by the principal, yada, 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 and I am acting in good faith. There are enforcement mechanisms for a POA that may entitle a party to attorney's fees in certain situations. And then the cases I've listed, and there's a multitude of cases for POAs, but the most problematic reason for somebody being sued over a POA would be because it did not strictly comply with the execution requirements. And in this first case that I shared with you, requires strict compliance, not substantial, strict compliance with the signing requirements. Maybe like the second case, the scope of the agent's authority, it went beyond the scope and the agent acted beyond what they were allowed to do. Maybe the superpowers were not initialed or separately outlined. Of course, you do have the situations where somebody has breached that fiduciary duty as well. and the agent can be held responsible for that. The unfortunate part is that it takes a court case at this juncture. These are, and I'm going to provide these at the conclusion of this CLE so that they are uploaded in the materials. These are just some samples of what my revocation looked like, what my specific for real estate looked like, and then my general durable, keyword durable power of attorney. And this document on the right is about 6 or so pages in length on legal size. And it's grown over time because I've seen a need to add more and more things to it. But I'll be happy to provide these in the materials following this presentation. There are also 2 additional resources that have been shared with the group and are also part of the materials. Florida Bar had a great short article on powers of attorney. And then the Department of Elder Affairs for the state of Florida had an Older Floridians Handbook, which talks about a multitude of things, one of which would be powers of attorney. And of course, this is my information. You are always welcome to reach out to me at any time if you have questions about a POA or if you need a template or maybe some guidance. Please don't hesitate to reach out. It really is one of the easiest areas, I think, to learn. And so I'm happy to help expand your practice if necessary. But I certainly appreciate you all attending the CLE today.
All right, Aaron, we do have one more question in the Q&A.
Sure.
I'm going to go ahead and read it out loud for the benefit of the audience. If a durable power of attorney is silent on granting the AIF, I'm assuming agent in fact specific authority to seek legal services or apply for benefits to which principal may be entitled, but grants authority to exercise, do or perform any act, right, power, duty, etc., that the principal has, is that valid for purposes of seeking legal services, bringing suits, etc.?
I don't know the answer to that without probably actually reading the language, all of the language in the POA. I would say that whoever asked that question, thank you. I just don't know. If he or she would like to email me, I can spend some more time to give you a more in-depth opinion on that.
There's another question here. Do you recommend young people give powers of attorneys to parents?
Oh gosh, yes. There's no reason why you shouldn't have one of these at 18, and that includes all of your estate planning documents. Estate planning, estate is a misnomer. People think estate because I have money. No, everybody needs a last will and testament at 18, as well as your living will, healthcare surrogate, POA, designation naming pre-need guardian.
All right. I'm gonna mark these as answered live. I don't think we have any other new questions. Let's see. I believe these are done. I keep seeing in the chat, you know, a lot of kudos to you, Aaron. Amazing presentation, really informative. I will update the materials with all these questions on the materials link, and I'll drop it again here in the chat. You will all get it on an email via Zoom. It will also be on YouTube with all these links as well. We can, if you have other questions that can come up afterwards, send them over to me, and I'll make sure to include those in the materials along with the templates as well. With all of that said, Aaron, thanks again for this amazing presentation. And if any closing remarks before we wrap up?
Nope, I don't believe so. Thank you all for attending, and thank you for asking me to present, and feel free to reach out anybody if you have questions.
All right. Have a great day, everybody.